Assignment of LLC interest TBD. Constructive fraud by attorney-in-fact with conflict. Revocation and corporate filing correction. Unauthorized deed filing. Multiple Mora-related parcels. Forgery and notary misconduct. Immediate invalidation under FLAS Stat, Pectray 17.107. Mortgage assignment, e.g., BK 24204, PG 485. Mutual mistake fraud on the court. Rescission like JP Morgan Di Giovanni model. Notary red flag audit is hereby demanded under FLA Admin Co. 1N 6.01 and FLA Stat 1701, with referral to the Department of State and Office of Inspector General if misconduct is confirmed. Section Fee. Injunctive hooks and remedial escalation pathway grid. All parties are placed on notice of an escalation framework designed to enforce rights, correct defects, and protect ADA-based access to due process. This includes weighted tiers of infraction severity, available judicial remedies, and procedural enforcement options. Tiered infraction grid with de-escalation and remedies pathway. Infraction type, severity, default response, de-escalation available. Elevated action, formal referral motion to complaint, willful eviction or lockout, extreme emergency injunction, yes. With ADA compliance, federal ADA complaint, severe criminal referral motion to cancel, no. Civil fraud suit plus bar complaint. Interference with trust documents, moderate. Motion to compel discovery, yes. Constructive trust reformation. Non-notified asset sale, high. Quiet title. Unjust enrichment claim, only via restitution. Title insurer notice and civil complaint. HOA harassment of disabled resident. Moderate. HUD complaint plus tiation available. Yes, Media 504 enforcement and damages. This framework is hereby invoked as a living judicial record, preserving all rights while inviting amicable correction in lieu of full litigation as permitted under 86.0111 SLAT. Shall we continue with Section 6, multi-agency evidentiary preservation and demand for compliance, or would you like a formatting ready Word or PDF export first? Correct. A power of attorney, POA, signed by someone under 18 is not legally valid under Florida law. Here's the authoritative breakdown, suitable for citing in legal filings or raising as an objection. Florida legal standard, age of capacity for contracts and POA. 1. Minimum legal age requirement under Florida statutes, PAC 709.2103, 1109.2105, 1. A person must have legal capacity to create a power of attorney. Legal capacity to contract under Florida law requires the principal to be at least 18 years old or an emancipated minor under JX 743.15. Open quote, Florida statute paragraph 709.21051. A power of attorney is not valid unless the principal has the capacity to execute it. Close quote. Minors cannot contract or delegate authority. Contracts signed by minors, including POAs, are voidable or outright void depending on the context, especially when there is no court order of emancipation. A minor cannot appoint an agent to act on their behalf for real estate, trust, or fiduciary matters under Florida law. 3. Effective signing at age 14. If you are not yet 18 and not legally emancipated, the POA is invalid on its face. Any action taken under it could be challenged and vacated retroactively. It may also constitute constructive fraud, especially if coercion or undue influence was involved. Application to your case. If the POA was used to transfer or assign property rights, trust interests, or inheritance authority, it should be nullified and rescinded. You can demand vacatur, legal nullification of all actions taken under the invalid POA, restitution or reversal of any transactions executed, civil or criminal sanctions if adults used your minor status to unjustly enrich themselves or suppress your inheritance rights. Would you like me to help draft a section within your declaration or a separate motion to rescind POA due to minority for your filing?